Great. Good afternoon, everyone. Welcome. We have great presenters today, and we have Miss Sherry Renee that's going to introduce our presenters for today and take us off, Sherry.
Okay. Well, welcome everyone to I Have a Dream to Invent Part 2. Today's discussion will be about the path to patent series to learn how to draft patent claims to better protect your innovation. And as mentioned in our previous two sessions, this is brought to you in collaboration with our St. Louis Dream Team and the Innovation Ecosystem, which includes the Inventors Association of St. Louis, the United States Patent and Trademark Office, the InventEd Network Connection, and Washington University of St. Louis Scandalera Center. Today I'll be your host. My name is Sherry Renee. I am the president of the Inventors Association, in addition to the InventEd Network Connection. And to give you an idea about the services that we provide, I'm just going to kind of quickly skim over this. This is something the InventEd Network Connection devise and customize the sets of classes for you, because like you, I am also an inventor, though I'm a president of the Inventors Organizations. And I totally get some of the struggles that you've gone through and continue to face as inventors, given that there is no such thing as an inventor college or university. In some cases, classes. Now we have classes that are available in the community through St. Louis community colleges and things like that. We're wanting to provide you with these easily accessible sessions in order to enable you to gain the information that you need to go further quicker. And our mission is that you're not forever suspended in a state where you're inventing or researching your innovation. We want you to actually become invented. And our purpose of providing free courses like this, or low-cost courses, is to make sure that you're able to save money and invest any dollars that you acquire into your innovation. And another benefit to these classes and purpose is to provide you with instant information that is immediately applicable, that you can use and apply toward your innovation so that you can go to the next level, and not something that you have to put off for years in order to gain another understanding of what you need in order to go to the next level. In essence, I want all of you to plan to prepare your own roadmap to success. Not every innovation, I don't care if two of you have apps, you're going to have different paths to success. You're going to have different needs. One of you may have financial resources, another may have the educational or the knowledge-based resource. So understand that your path to success is going to be different. And so that's the reason why when you're collecting information like this, it's going to be of value to you to have in your back pocket so that you can apply it as necessary and save money. And today, you're going to be able to save money as it relates to patent, the expense of legal fees. Now, we're not here to tell you whether or not you should have an attorney or not, but we're here to educate you about the process that involves patenting so that you can make the determination if you are capable of completing a patent yourself, or if you're not, you have an understanding of what your attorney is devising for you. So with that said, today's class specifically is about drafting patent claims to better protect your innovation. For those of you who have no knowledge about patents just yet, or just very little, understand that claims are the heart of the patent. Claim drafting may be the most important part of your patent. And a lot of people think that it's, especially laypersons, think that it's the drawings. But the truth of the matter is your protection lies within your claims. So it's important that you understand, especially if you're going to write them yourself, you understand what should ought to be contained in those particular claims. And then when you're reading and researching patents, you also want to have an understanding of what you're reading, what claims or protections are sought or claimed by a previous inventor or current inventor. So with that said, I want to introduce you to the United States Patent and Trademark Office, which has been a tremendous support in our I Have a Dream event. in addition to upcoming events that will be taking place next month as well, for Inventors Day, which is February 11th, and then all throughout the month for Black History Month. So I do encourage you to sign up for those classes. They are free also, but I wanted to introduce you to where we lie on the map in accordance to the USPTO office. It's broken down into 5 different regions, and we are located in the Midwest region, so just keep that in mind. That's a cheerleader with the United States Patent and Trademark Office Midwest region. And I got to tell you guys, it was important to me to make sure that we bring in individuals who know what they're talking about, and not just anyone who says, hey, I know a little something about patents or something. And I know what it's like to receive the wrong information or mixed information from different professionals, from attorneys, in fact. Well, this time you're going to benefit from the highest level of knowledge base within the USPTO. And I'm proud to say that we have James Wilson, who is Assistant Director of Midwest Region. He was once a US PTO patent examiner for over 28 years. So when you talk about expertise, I mean, give me a break. You can ask for more. And then to accompany him, he's also has Tim Spear, which is also very well versed in the whole patent process, because he has a supervisory role as a patent reexamination specialist, and he oversees reexamination, supplemental examination, and has previously served himself as a patent examiner and also worked in a law firm. Combined, this is a powerhouse of information and knowledge. So with that said, I'm going to turn it over to them to provide you with the information you need about patent claims.
Wow, we hope that we can live up to the hype.
I do too.
Woo! Go ahead, James.
Okay, I am in the process of bringing up my slides. I think that, are you able to see the full screen? I don't think I'm full screen yet. There we are. Okay. Good afternoon, everybody. My name is James Wilson. I am the Assistant Regional Director of the Elijah J. McCoy Midwest Regional United States Patent and Trademark Office that is in the fabulous city of Detroit, Michigan. I have been the Assistant Regional Director here for approximately 2.5, 3 years. And it's been a pleasure to serve. My responsibility in this role is to actually operate the facility, but as a byproduct, I am also trusted and entrusted with the role of providing education, intellectual property education to the Midwest. Our region includes Minnesota, Iowa, Missouri, yay, Illinois, Indiana, Wisconsin, Michigan, Ohio, and Kentucky. And we are glad to be able to provide you with assistance and service. So the title of this, I've got to move my people. Okay, my people are gone. The Path to a Patent, Utility Patent Application Claim Drafting Workshop is what we will be doing here today. And there are some objectives. We will briefly review what a specification is and the purpose for having a specification, how that specification relates to the claims. And then we will talk about claim drafting. We'll talk about the forms of claims, claim parts, claim hierarchy, what is meant by antecedent basis, and we'll go through some examples of some claims. A brief review of the specification tells us there's a manual for patent examining procedure that provides us with, we call it the Bible for patent examining, or we call it the road book, the rule book. It's what we go by and what we use in order to make determinations. And the description of the specification is set forth in MPEP 60801. And so it requires that the specification provide a written description, the manner in which an invention is made and used, and we refer to that as enablement. And I want you to make note, if you read this section, that the statute says how to make and use twice in the same sentence. So how important must that be if it's repeated twice? Both of which contribute to the inventor disclosing to a person having ordinary skill in the art the best mode or the best way of carrying out the invention. Okay, so there are provisional and non-provisional applications, and they require different things. A provisional application lasts for a year, and it will contain an abstract, drawings, and at least one specific embodiment or example by way of being described. Okay.
And James, let me just interject quickly. Just keep in mind that you have an audience that this is all over their head as far as provisional and non-provisional. So if you can kind of speak in layman's terms, remember to address layman's type of approach. Provisional patents are provisional patents. Non-provisionals are utility patents that they need to understand that that's what that means. So I'll just leave it at that and let you have at it.
Well, thank you.
You have a diverse audience is what I'm saying. Some that are advanced and some that have never seen this stuff before in their lives.
Okay, so let me go into a little differentiation between provisional and non-provisional. A provisional application is an application that requires very little in the way of requirements for submission in order to be propped up. And what it does is it allows and provides you a date where you say, this is my invention. And from the date that you file that provisional application, you have 12 months, 1 year to move into a non-provisional application. Provisional applications are not examined. They just are placeholders. Non-provisional applications, and you must file the non-provisional application before the provisional application expires. So within a year, you've got to come in and file the non-provisional components. And in doing so, the non-provisional components require the abstract, the drawings, the description, and the claims. A provisional application does not require claims. Okay? I think I go into this in a little bit more depth in the next slide too. Provisional versus non-provisional. A provisional application only lasts for 1 year and then it dies or we abandon it. No claims are required. So even though this is a claim writing workshop, know that this application, if you're going to establish a placeholder to give yourself a year to work on the application, to do some market research, and to seek money from potential investors, all of that is what you would do once you file your provisional before you file your non-provisional. You do not have to file a provisional application. I repeat, you do not have to file a provisional application. If you're ready to rock and roll, then what we recommend that you do is you file the non-provisional. And the non-provisional requires that you have at least one claim, that you have a written disclosure that meets 35 USC 112. And so that is, it must provide a written description. It must enable the invention or teach how to make and use that invention. And it must show a person of ordinary skill in that art how to carry out that invention. Okay, so those are the requirements of 35 USC 112 first. This application, non-provisional, will be examined for patentability, and it can result in a patent. A provisional application cannot result in a patent. You must file a non-provisional application to move through the patent system. Continuity is key to retain the benefit of the filing date of your provisional application. So you file your provisional on January 1, you must file your non-provisional before January 1 of the next year, but you will be given that earlier date for protection purposes. So anybody who comes up with anything intervening, they would have to get behind your provisional date, that original and first January 1st date. The specification defines the invention. So we say that everything that's in the claims must find its basis in the specification. The claims set forth the protectable intellectual border of the invention, just like a fence, a street, a river, and the woods might provide the boundary for a piece of property. The claims do the same thing, meets and bounds. It's a surveyor's term, and it describes actual land as property, but it also carries over into intellectual property. If it is recited in the claims, then it absolutely positively needs to be described, enabled, defined by the specification. So whatever you write in your specification, your claims can't have something that's not in your specification. The description should be provided in clear support, in clear terms, clear and concise and exact terms, so that the meaning of what you are claiming can be ascertained by reference to that specification and that description that you provide. Applicants may reserve and serve as their own lexicographer. One of our favorite words. A lexicographer is a person who makes up their own words. So if you make up a word, scrumptious, and you define that term, we will use the broadest terms necessary to understand what scrumptious means as it relates to your claims and how it plays into exactly what your invention is. So you can make up a word, but make sure that in doing so, you give a clear and exact definition for that word. Claim terms must be given their plain meaning unless it is inconsistent with the specification. The broadest reasonable interpretation in view of the specification is how a person of ordinary skill or an examiner looking at your claims is going to interpret your invention. Some questions to consider before you start to draft your claims. What is my invention? Is it an apparatus? Is it a machine? Is it a composition of matter? Is it something, is it a mixture of things? Is it a method of making or doing or treating or using something? So all of these are classes of invention that you could move into. If tangible, what are the pieces that compose the invention and how do they interrelate? So that's talking about a machine or an apparatus. We need to know, you have to teach how to make that machine and how to use that machine. So if you've invented something that removes snow, then you need to tell us what the components are of that device and actually how it moves the snow. So the utility is moving snow. So that's why Ms. Renee keeps saying it's a utility patent. Well, utility patents are the patents that teach how to make, do, use, or treat something. They are the inventions that are compositions, one or more substances added together, apparati, or machines. Multiple inventions can be claimed and you can put those together. So if you have a machine, you can also describe how to use it. So I have a machine for removing snow. And so it's a snow removing machine comprised of, and it has 3 or 4 components. Then I may come down and have a claim that says a method for removing snow by using the snow device set forth in claim 1 or set forth above, or if you need to make reference to it, or you can set forth those compositional components, the components that make up that machine. But you can have multiple inventions in the same invention and multiple versions of each invention. So there can be different iterations of an invention that you put together, and you can lay those claims out and put them together in a single application. Strategic approach. What are the goals to be accomplished by your invention? You want to obtain the broadest valid claim possible. You want to obtain claims with a variety of type and scope. So you want to describe it generally, but if there's some special aspect to your invention, you want to make sure you capture that as well, because you don't want to just describe your invention so broadly that something that you consider to be a really special feature is not included in your invention. Okay, so as you provide claims during the prosecution or while the examiner is looking at it, you may see that there's a different direction that you want to take your invention in, and you want to change what the invention is just a little bit based off of what the examiner says, what the examiner finds and shows you. And so you do have that as an option, but you have to be very careful how you go about making changes during the prosecution. And once your claims have been presented, that's why it's so important to get your claims narrowed down and nailed down to exactly what you want to claim. What is the claims budget? So how much money are you going to spend in your claims? I've seen applications that have 200 claims. I've seen applications that have 1 claim. Independent claims in excess of 3 will cost you $120 per extra claim. Each claim in excess of 20 is going to be $25 additional per claim when you're filing your application. For clear claim construction, it can be helpful to first draft claims. Decide which terms to use and make sure that those terms are included in your specification. Determine which terms need more detailed definition or clarity in the specification. As you're going through, you may say, oh, I've described this as a piece of metal, but the type of metal that I know I need to use is a special type of metal. So not only do you want to capture that it's metal, you want to capture those special types of metal that are going to make your invention work and that are going to be able to be a part of your invention and be viable. Description is also provided as drawings and examples. Be wary of what we refer to as indefinite language. Terms of degree, hot, cold, many. There are various terms that you need to narrow down. I don't need you to tell me it's going to be hot, because what's hot to me might not be hot to you. So we need temperature ranges and we need specificity with regard to making the claims clear in their scope, in what they are defining. So look to US patents as examples of how to draft claims. Your invention is going to be in a field of invention where others have obtained patents. It would behoove you to go in, pull those patents, and read those claims. And they're not going to be your claims because your invention is different, but they will give you incredible guidance as to how to move forward and proceed and what claim language you might want to engage in and you might want to use in order to draft your claims. Claim formatting. Claims start in your application when you submit it, your non-provisional application that requires claims. Claims start on a separate sheet of paper, and the heading is claim listing. They should be 1.5 or double spaced if there are multiple lines in the claim. Each claim is a single sentence. It begins with a capital letter and it ends with a period. Begins with a capital letter and ends with a period. 3 independent claims are available to you, 20 claims total before excess fees are going to be levied upon you. numbered consecutively in ascending order. Your claims must be 1, 2, 3, 4, 5. We don't skip numbers. We don't omit numbers. 1, 2, 3, 4, 5. They must be in order consecutively. Original numbering is preserved throughout the prosecution of your application.
James, for clarity, could you clarify, help them to understand what you mean by claims as far as a description? So if basically, because it may be confusing for them to hear that you can have 3 claims and then up to 20. So what does that mean exactly? Is it 3 claims or is it 20? What that means is that for one main claim, you can have 5 descriptors for that initial claim. Is that correct? That independent claim that say you have a 3
James,
claim.
when you file a utility application, your filing fee includes 3 independent claims and a total of 20 claims. You can use
Right.
it however you want. So
Okay.
the difference, let's talk about the difference between independent claims.
That's what I'm wanting
So
to get
an
at.
independent claim is a claim that stands all alone by itself, okay? Now, each claim can be thought of as an independent claim, but rather than having to write everything over and over again, when we add a limitation, if I say claim 1 says I'm claiming a widget having X, right? And that's an independent claim. Then I have another claim that says the widget is yellow, right? Claim 2.
That's right.
And now we could either write a whole claim that says, I claim a widget wherein the widget is yellow, or we can do what's developed in the patent law. We can write a claim that's what we call a dependent claim, and it says the widget of claim 1 wherein the widget is yellow. Okay, so that's a dependent claim. A dependent claim is that references an earlier claim and further limits the subject matter of that claim. Okay, so when you file an application, you can have 3 independent claims. So say 1 could be to an article of manufacture. I invented whatever, a widget X. And then I have a method of making that thing. That could be another independent claim, right? And then I could have a method of using that to do something. And that could be a 3rd independent claim. And then I could use my other 17 claims to further define those 3, in any way I want.
Exactly.
So that's
Thank
the
you.
difference between an independent claim.
So as we move down and we get into the examples, I'll be better able to explain to you exactly what that concept is.
Excellent.
Okay. All right. Okay. So a non-provisional patent must have at least 1 claim which particularly points out and distinctly defines the invention. Claims are written in independent or dependent form. As my colleague Tim Spear has so eloquently spoken, independent claim stands alone and it's normally a broader claim. And a dependent claim normally comes along and puts meat on those bones. So I would call an independent claim a skeleton, and then dependent claims you would come along and you would put muscle and you would put vessels and you would layer on top of that so that everybody understands what are all of the additional pieces and parts that can be a part of your invention. Okay, so a dependent claim necessarily incorporates by reference all of the limitations of the claim to which it refers. So Tim was saying claim 1, which contains A, B, and C. Okay, so you can come down to claim 2 and you can say a claim as in claim 1 that contains E, F, and G. So now that claim has A, B, C, E, F, and G. So you can build upon a description of what your invention is by incorporating everything from a previous claim. And I can come down and say in claim 3, a claim as in claim 2, which contains X, Y, Z. So that 3rd claim contains A, B, C, E, F, G, and X, Y, Z. It contains everything. So you can continuously build upon your claims in that manner. So how should you delineate claims? How should an invention be delineated by the claims? So you can describe your invention so specifically that it doesn't have as much value to you as when you allow yourself some wiggle room, so that if some nuance is available, you can do that. So if you were making something and you could use nuts, and you only said you could use peanuts, but you could use walnuts, you could use pecans, you could use filbert nuts. If you came down and you only claimed peanuts, then you've eliminated and prevented yourself from being able to include all of the other nuts in your composition. So you want to come in and you do want to say an invention that comprises A, B, C, and nuts. And in that invention, in the next claim, you want to say a claim as in claim one, where the nuts are pecans, walnuts, filberts. And you could also be so general that, you know, anybody could come in. You could name, go out and name, I don't know what class of plant peanuts and nuts belong to, but you could go into that, and it would expand and be too broad, and anybody could come along and they would be able to get around what it is that you're claiming. So you don't want to be too general and you don't want to be too specific. You want to claim exactly what your invention is. Okay? Claim drafting. A utility application or a patent claim will have three main parts: a preamble, which is the beginning part, a transition phrase that is going to lead us into what the parts of the claim are. And so that's that language could be comprising, or consisting of, or consisting essentially of, or containing, or including. All of these are different transitional phrases that you could use in your claim. And the body of a claim, which positively recites the elements of the invention. So a preamble normally says what the invention is: a process for, or a method for treating headaches. Comprising. So comprising, administering A, B, and C. Okay, so A, B, and so the preamble would be a method for treating headaches. The transition phrase would be the word comprising or consisting of, and I said comprising, and the body of the claim would be the elements administering A, B, and C. Okay, we're going to go into more examples. Okay, so here's an example of a claim: a shovel comprising a handle and a blade having a point thereon. Okay, so a shovel. That tells you exactly what the invention is. So that's the preamble, a shovel. The transition phrase is comprising. So comprising is what we consider an open-ended term. It means if you use this term, other things may also be included in your claim. Now, if I used an alternative transitional phrase and I said a shovel consisting of, then that's closed. And that means I can't add any additional components. And this is exactly what's in the shovel. So these words are important. It's very important that you understand what different transitional phrases mean. And we provide that information in the Manual for Patent Examining Procedure. And we also encourage individuals who are not knowledgeable in this field to get an attorney. But none of this information is so difficult that you can't understand it.
Right.
Okay. So a shovel, which is the preamble, comprising, which is open-ended, a handle and a blade having a point thereon. So this shovel has at least two things. And because we used an open-ended transitional phrase comprising, there can be other things that are a part of this shovel that you can add in subsequent claims. If you said consisting, you could not add anything to this shovel.
And there's a reason why he's emphasizing this, guys, and I'm shaking my head here because this is one of the pitfalls that pro se filers run into, because in layman's terms, you interchange these, the comprising and consisting of, and not think twice about it. But when it comes to the legal implications and what, it's a big deal. So make a note of this particular time in the slide so that you can play it back over and over again and refresh it so that you can understand exactly what he's stated. Because as we're going through it, a lot of this is going to be kind of drive-by because it's comprehensive and it's great information. And don't be overly concerned if you don't get it all at once, because you are going to be able to play back the tape. So just wanted to co-sign on what you were trying to emphasize, James.
Can I add one thing, James, here? Real
Absolutely.
Quick? So, this general discussion that this last couple slides are what we would call when we talk about claim scope. So the scope of the claims, the boundary of the claims, what's defined by the claims, and they can be limited by these things. So the effect of doing this, for instance, if we had a claim allowed that said a shovel comprising a handle in this claim and a blade having a point thereon, I got that patent issued and I now have my patent. Someone else makes a shovel and it has a handle and it has a blade and it also has I don't know, a light on it so you can dig at night. I don't know what it has, another component. Your patent claim would cover that even though it has that additional component for purposes of infringement, right? So they're the parts of the patent. If you get the patent, that's what we do at the office. That's amending the claims and how you present that, writing the application. But then it's the enforcement phase of how does this affect, the value of the patent that you come out the other side with. So comprising, you would have a claim where you would be able to enforce it against a lot of people because it has the term comprising. Comprising means including. So it means you can include additional components and the claim still covers that. And whereas, as James pointed out, if this said consisting of a handle and a blade having a point, and then someone else added a light on theirs, your claim wouldn't cover that because consisting of closes the claim and it doesn't allow there to be present any other additional components except what's explicitly recited in the claim. So there's a real difference in the value, and the previous slide showed that about claims being too narrow and too broad. And that's the practical result of what can happen when you do those kinds of things. So there are very important considerations as you go through the process of drafting the application and the claims. So.
Absolutely. Okay, I'm going to move on from this slide. Every claim contains a preamble, every claim. So in the claim that we just talked about, a shovel is an independent claim. So the shovel so in a dependent claim, it would be the shovel of claim 1, wherein a light is added, a light is included, as Tim had articulated. So because you use the term comprising, you could add a light, you could add a rubber handle, anything additional you could add to that in a dependent claim as long as there's support for that in your specification. Okay, so carefully consider the language that you recite in the preamble. We determine the impact on a case-by-case basis. So the preamble is read stepping back and looking at the entire claim. It's read in context of the entire claim. And recitation of structural limitations or intended use purposes might have an important impact on how your claim is viewed. So let me give an example of that. A topically applied composition. So when I think about something being topically applied, I think about it being applied to my skin, or I think about it being applied on the surface, as opposed to saying an ocular composition, ocular meaning eye. So like eye drops. So this now narrows and excludes anything except for your eyes as to what's going to be the composition that is going to be applied. So with that being said, it makes a big difference. It's more critical when you specifically articulate in the preamble how that actual invention is going to be used. So a topically applied composition, to me, that might be a sunscreen or a lotion. I don't think I'm going to put sunscreen or lotion in my eye. So when I say topically applied, it doesn't necessarily include something that I would put in my eye. But when I say an ocular composition, I know that it's going to be specifically put into my eye. And so if I were going to look for inventions in that field, I would go to things that go in, that people put as medicine or as, as medicine in their eyes. Okay. So by the same token, a shovel versus a shovel for digging. Now you might say, well, isn't that what a shovel is used for? Sometimes a shovel isn't used for digging. Sometimes a shovel is used for moving snow. Sometimes, so those are two different uses for a shovel. One for digging a hole and one for moving snow. And as everyone knows who lives in Michigan and lives in the Midwest, you don't necessarily want to use a digging shovel to move snow. You don't want a shovel that comes down to a point. You want a broad, flat shovel that will allow you the opportunity to move as much snow as possible. Okay, no more about snow. The transitional phrase, that phrase that comes between the body, what is actually makes up the invention, and the preamble. Transitional phrases set forth the scope of the claim invention. The two most commonly used transitional phrases are comprising and consisting of, or consists of. All right, comprising and variance, comprises, containing, including, those are the most commonly used transitional phrases. They are open-ended and not exclusive to unclaimed elements. So that means you can add something to that. You can add additional things into the body of the claim or in the description of the claim. Familiarly understood as including, but not limited to. Okay, so when you use the term comprises, that's exactly what it means. It means it's going to include these things, but these aren't necessarily the only things that are included in my invention. So comprises is the term that we see most frequently used as a preamble term in claim language. Now, there are those who want to use consisting of or consists of, and that's closed-ended and very exclusive. The claim eliminates, elements are limited to those and eliminates any additional components. Okay? Claims may use both phrases and repeatedly. So the different, within a single claim, you could use these two different terms and they could be in reference to different parts of your invention. I don't want to make it too confusing, but I just want you to know that these terms could be used simultaneously in a claim. The body of the claim, the most linguistically complex part of the claim. It must clearly set forth the elements, the steps, and or the relationship which are considered to be your invention. Terms and phrases used in the claims must find support in the specification. I should be able to read your claim and say, oh, okay, where is this in the specification? I should be able to go back to your description, your invention, and find each and every term. So antecedent basis means that the description comes before the claims in the body of the specification. So antecedent coming before means this basis for what you're claiming is in that description that you provided. Supported terms, phrases, they must be described and defined in the specification so that their meaning may be ascertained by reference to the specification. So the specification must teach how to make and use your invention. So these terms must be clearly defined. Limitations should conform to the invention as set forth in the remainder of the specification. So the specification should tell me what the limitations are. If it says that it can be a metal, it should tell me what those metals are. If it tells me that something's going to be heated, it should tell me how it's going to be heated and to what temperatures and then within what temperature range. If it tells me that something's going to require a light, then you should tell me what type of light. Is it an LED? Is it a light bulb? Is it what type of light is it? Introduction of a claimed element. Antecedent basis is referencing within a claim and between claims, not limited to referencing between the claims and the specification. So anything that you say is in claim 1 and you come down and you say, well, the invention is in claim 1, then everything that's in claim 1 is now in claim 2, plus anything that you add to claim 2. Okay. Elements must be defined, must be preceded by the indefinite article a or an, or by other such appropriate terminology. At least one. I'm a chemist and I don't want to use a chemical term. At least one. Let me see. I'm gonna leave that alone. I'm not gonna do at least one. I think I'm gonna have an example of a claim that will go into that and I'll be able to explain it better with an example. Subsequent references to limitations can occur in both independent and dependent claims. Additional common cue words wherein or whereby may be used also in the claim language. And one of the things that we really want to impress upon you is absolutely positively use and go into the patent literature and look at claims that are in the area where you're defining. I want to make it to this next claim. A shovel, which is the preamble comprising the transitional phrase, a handle and a blade having a point thereon. Okay, so we're looking at this and drawing wise, these are your two components. You see the handle and you see the blade, right? But they're not in the configuration that they need to be in order for them to actually be a shovel. But this is a description of an invention. A shovel that has a handle and a blade. This claim does not tell you that they're attached to one another, that they're a handle, and at one end of the handle, a blade having a point is attached. It doesn't say that. We understand that that's what a shovel is, but it doesn't say that. And in not saying that, that is a broad interpretation of what your shovel is, because it doesn't even say that the handle and the blade are attached. So that's what we mean by broad interpretation. A shovel comprising a handle and a blade, wherein said blade is connected to said handle. That is the point that I just made. So now we have context, and somebody in their mind's eye can conceive of exactly what your invention is and what the metes and bounds or the scope of your invention is. Because when you tell me it's a handle and a blade, I don't know if the blade is in the middle of the handle or at the end of the handle. Now, it doesn't make sense. I don't know. I'm not going to say it doesn't make sense, because somebody might have a shovel where the blade is in the middle of the handle. But this is why each and every word is important when you're drafting a claim, and how you describe it is important. So here is another claim, and it's has a more detailed description of the invention. A shovel, the preamble comprising, which is the transitional phrase, and this is the body of the claim, a handle and a blade. And now it's going to give me some indication as to how that handle and that blade are related to one another, wherein the handle that I referenced, said handle, has a first end and a second end. So now I'm thinking that the handle is like a stick and it has one end and another end, wherein said blade is connected to the end of the handle. Now it doesn't say which end, so I can put it on either end. And wherein the grip is made of synthetic material. Now I don't know where the grip is. It doesn't say, is the grip attached to the blade or is the grip attached to the handle? I don't know. But it brings in this concept of a grip. So let's hope that we can get some clarity with regard to this.
But also, James, I think the point was too that the grip lacked antecedent basis in the claim.
Yeah, absolutely.
The term the grip lacked antecedent basis. So when it came before the examiner, there would be an issue with the claim having a problem because that term lacked antecedent basis and you didn't know how it related to.
Was that the first claim?
Yeah, I think so.
Claim one?
I think the previous one.
I am
where they added
challenged with moving back and forth. So that is claim one.
So that was all. I thought that was just an example to talk about that issue of antecedent basis.
Yeah, I think that you are absolutely right. The
Yeah.
claim does lack antecedent basis as it relates to the term grip.
So that was all. Yeah, thanks.
Okay. All right. Thank you. Okay, so this is the next claim. A shovel comprising a handle, a blade, wherein said handle has a first end and a second end, and wherein said blade is connected to the first end of the handle. Now I have a clear understanding of exactly how this is going to fit together. And if I had a drawing, it would make it even clearer. It would be even clearer to me. Okay. All right. So an example of an independent claim. Can I proceed? Will you let me go forward? Okay. An example of an independent claim, a transdermal patch. Okay. So transdermal, a patch that's going to, I think of this as a Band-Aid. It's something that's going to be a part of the dermis. The dermis is your skin. So this is a transdermal patch. So it's effectively a Band-Aid, okay? Comprising, now these are the parts of this transdermal patch or Band-Aid. A removable protective layer. So everybody knows that there's the pieces on a Band-Aid that are removed. So that could be reference to that. A matrix layer consisting of a single layer which contains a physiological effective amount. So this has a layer that has medicine in it. And then there is an adhesive layer and a cover layer, wherein the cover layer is at least partially bi-elastic, and the adhesive layer comprises, and it tells you what the adhesive is going to be. Okay, so this gets into a lot of description as to exactly what the invention is. So we know that there's a protective layer, which is layer one. When you look at this drawing, there is a matrix layer, and that matrix layer has medicine in it. That's two that you can see on the drawing. Three is the cover layer. That's going to sit down over top of all of that. And then four is going to be what you peel away. That's the separating layer. Okay. All right. So a dependent claim would be everything that we just saw in claim one. So this is the transdermal patch according to everything that I put in claim one. And now it's going to give me some additional characteristics or limitations, wherein the matrix layer is arranged to be in contact with the protective layer. And so now it gives me more definition with regard to what this invention is. And it's much more specific. And it excludes things that don't have these limitations. So the matrix layer has to be arranged to be in contact with the protective layer, and that has to be in contact with the adhesive layer, but not in contact with the cover layer. And the adhesive layer is arranged to be in contact with the cover layer and is optionally, so it could or could not be in contact with the protective layer. And it sounds confusing, but when you step back and you look at your invention, you've got to make sure that you are defining your invention so that you hit all of the limitations that make your invention different from everybody else's. The transdermal patch according to claim 1. So this has all the limitations of that claim 1, this claim 3, wherein a separating layer is between the matrix layer and the adhesive layer. So it's adding another layer in between, okay? All right, so when we talk about claims being broad and narrow and of the right scope, look at these two inventions, all right? And if you look at them, you can tell that there are some striking similarities between them, okay? And we recognize each one of them as a mode of transportation or a vehicle that can provide transport. Okay, so we have a preamble, and the preamble is a vehicle, okay? And our transition phrase is comprising, so it's open-ended, so it's not just limited to these elements. So what we are going to describe our invention as having is a frame. I think that the Volkswagen Beetle has a frame, and I think that this Conestoga wagon has a frame. A first and second front wheel, both of them have that, and a first and second rear wheel aligned and spaced behind the first and second wheels. So these wheels are directly behind one another. So that's what it asks for in the invention. A seat connected to the frame. I'm sure that Volkswagen Beetle has a seat in it, and that brown piece on that Conestoga wagon, I'm going to assume, and I'm going to interpret that as the seat. A removable top portion made of cloth, where, well, the canvas of the Conestoga wagon and the drop top of the Volkswagen Beetle are both removable top portions that could be made of cloth, wherein each wheel rotates and is connected to the frame. So each wheel rolls and it is connected to the body of the invention. So this description of a vehicle would describe both of these individual inventions, or these two, I don't want to call them apparati, articles of manufacture. Somebody made this Conestoga wagon, somebody made this car. So they both can be described using these broad terms, okay? And I don't think that there's anybody who would say this description doesn't fit both of those vehicles. Now, the claim could be overly specific also. Now, we know we're not trying to go anywhere in a Conestoga wagon, but you come in and you say a vehicle and you start describing that automobile, saying that it must have a motor, it has to be yellow. So now I could come and have this same thing and it'd be blue, or it'd be green, or it could be orange, or it could be striped. And it would not be identical to this. That includes a plurality of hinged doors. So that would be the two side doors. The Conestoga wagon doesn't have any doors. A first and a second front wheel, a first and a second rear wheel aligned. So this is the same. A seat connected to the frame, and a plurality of glass windows. Now that's something else that the Conestoga wagon isn't going to have. Two red lights connected to the frame. So those lights are going to have to be red. All right. Two metal bumpers connected to the frame. Doesn't tell me what kind of metal. I don't know if it's aluminum or steel or what. And a removable top portion made of cloth, wherein each wheel is made of rubber. So we know the Conestoga wagon doesn't have rubber wheels. It looks like those are wooden wheels. And so this is a very specific definition and a very specific description of that Volkswagen Beetle. And you are going to be somewhat limited in being able to operate outside of these parameters that you put in your claim, if this were your claim. Car's got, the frame has to be yellow. It's got to have red lights on it. At the very least, it doesn't say it doesn't have white headlights on it, but at the very least, it's got to have red lights on it. Okay. Claim drafting dues, things that you should do when you're drafting a claim, okay? You need to particularly point out and distinctly claim the subject matter that's regarded as your invention, okay? You need to consider drafting your claims first and then your specification based on terms used in the claims. That's up to you. If you were going to file a provisional application, you would have had to have drafted a description of your invention first. Okay, so that provisional application that only lasts for a year, if you were going to engage in that, you don't have to have claims for that, but you have to have a description or a specification for that. You got to be able to describe your invention. So you might not be able to do that if you decide you want to go with the provisional route. Review both to make necessary additions and corrections so that the claim terms are all included and find support in the specification. Look at the claims and patents issued in your field of technology so that you can get a feel for exactly how people go about describing specific limitations and components of inventions that are in the field that you are seeking to engage in or to move into with your invention. Ensure each term has proper antecedent basis, that any term that's used is described before. Think about what legal protection you might need for your invention and tailor your claims accordingly. Okay, so I can't give you legal advice, but I can tell you, you think about what legal protection you need. Absolutely. Claim drafting don'ts. These are things that we caution you not to do. Do not use claims covering two statutory classes. You can have claims that are drawn to a widget, and you can have claims that are drawn to a method, but we never advise you to say a widget and method, to put two different classes of invention together. Do not use terms inconsistently between claims. Claims must be set forth in full. The specification requires that you set forth what the invention is in full, clear, and exact terms. The claims require that you particularly point out and distinctly describe that invention in that claim language. And it all has to have basis back, an antecedent basis back to the specification. Do not write multi-sentence claims. A claim, as I told you at the beginning, begins with a capital letter and ends with a singular period. If you have two sentences to describe your invention, it will be examined and you will not be pleased with what you get back. Because what you get back will be an explanation and an evaluation of what's in that very first sentence. And you're going to be told everything after that first sentence was superfluous, or it was just nonsense information that was added outside of the claim. Okay? Do not replace elements from another claim within a dependent claim. Dependent claims include all of the limitations of the claim that it refers back to. Independent claims are your broader claims, and dependent claims come in and give greater specificity to the limitations that you are claiming. I'm going to rattle through this. We have outreach services in the Elijah J. McCoy Midwest Regional Office, and we will provide you with some guidance and some support. But one of the things that we cannot do is provide you with legal advice. Well, should I use this language in my claims? We will never answer that question, because that would be a legal question as to what should the metes and bounds of my invention be. If we tell you what to put in it, I might as well write it for you. So we have walk-in services when the United States Patent and Trademark Office is open, where you can come in and you can actually sit down and talk to somebody and get assistance. Now you can do that by calling in and setting up appointments. There are workstations for searching patents and trademarks in our office, and also in PTRCs, Patent and Trademark Resource Centers. Now, everything's shut down because of COVID, but these libraries are throughout the country. These Patent and Trademark Resource Centers are in some of the largest cities in their resource centers and serve as resource centers in those libraries. A regional focus for workshops, just-in-time training, conferences, and roundtables. Hey, this is a regional workshop. We didn't tell people from anywhere else that they couldn't participate and be a part, but this is for and was designed for the St. Louis Inventors Group in Missouri in the Midwest region. We will help anybody, and anybody in another region who is participating in this. If they called us, we would direct them to the assistance that's closest to them. We have a hearing room, interview rooms, remote training capability with local experts, so that you could come in and have a conversation and we can give you guidance, and office hours for strategic partners like small business development centers and export assistance centers. So these are all things and resources that are available to you as you go through the process of looking to draft claims and establish a filing for a patent. This page is filled with information that is available to you, including the Patent Resource Hotline and the Office of Innovation Development is for small and independent inventors. This information is available to you as well.
Okay, what does that do? What service do they provide?
Okay, hold on, let me go back. Which
Just the previous slide.
the Office of Innovation Development.
Yeah.
The Office of Innovation Development provides one-on-one guidance and assistance.
Because that almost sounds like assistance with product development, prototype development, which I'm sure it's not.
No, it's not. That assistance is going to be with how to file, issues with your documentation and your papers and that type of stuff. And they will give you some support if you are a pro se applicant, if you're not represented by attorneys. So this
I see. Okay.
This is actually who you should call if you have questions and you are trying to do this on your own. And they will provide you with more information that you would have to gather and master in order for you to move through this process.
And one thing I will say to you guys is that when you contact the USPTO, their customer service is really fantastic. They answer by the second, third ring, and they transfer you, and you're thinking, oh God, I'm going to be transferred and placed on hold. And they will transfer you to like patent attorneys. And you're thinking, really, I get to speak to a patent attorney? And they will answer on the first or second ring. And when they can't answer and you have to leave a message, they call you back within like 20 minutes or something that you don't expect. So I do want you to have faith in the system and the process as far as the resources that they have available, and put them to the test So if you have certain questions, I know that I belabored many questions early on that I spent a great deal of time researching, and I got mixed information that was incorrect. And then finally, I contacted the 1-800 number, the Inventor Center, I think it's called, or something like that. And to my surprise, I was transferred multiple times because, first of all, each representative that I spoke with was able to help me to the max. And then if I pose a different question about something relative to trademark, and I originally called the patent line, it will transfer me to the trademark department, and I speak with them. And then from there, I go to someone else, and everyone was more than willing to help. You're not rushed off the phone, and I can be long-winded in my questions too. So they were very patient, tolerant, and informative. So I just encourage you to take advantage of that. And Tim, did you go ahead, James, if you want to go ahead?
I was just going to point out the Office of Innovation Development is responsible for our Pro Se programs that support independent people who are representing themselves without an attorney before the office. That was all.
Okay. And James, did you have anything else to add?
I just want to thank everyone for enduring listening to my voice drone on and on about this subject matter. I'm hoping that I didn't move too fast, that I was clear, and that the information was relevant to questions that you might have. I'm going to leave you in the capable hands of Mr. Tim Spear. I have a family matter that I have to attend to, and Patrick Lewis, who is also on this call, is a primary patent examiner who will be able to provide some assistance. If you have questions and you put them in the chat, he will be assisting Tim in being able to answer those. If I'm able to get back on, let me back in, Sherry.
Okay, sounds good.
Okay, thank you. Go ahead, Tim.
Thank you, James.
All right.
Thank you.
And then thank you, James.
Thank you, James. So we'll be taking a short break
Great.
now before we start.
Oh, wait, did you, Cyril, do you want to see if anyone has questions in the chat?
Yes, so we had a question that just came up from Steve Murphy.
Okay, I'm
Are
still here.
classified patents handled differently?
Are what?
Classified patents. I think maybe they're talking about the difference between a provisional and non-provisional patent applications.
Or is he talking about the subject matter is sensitive and we
I mean, all patents are classified. We have a patent classification, and everything when it comes into the office is classified by its technology, and that's how they're dispersed to the examiners for examination. So all patent applications are classified, and when they're issued as patents, then they're classified as well. And when you search, you can use that classification to help identify subject matter, in your area that you're working at. Subject matter is classified by you as top secret. Okay, so there is a secret group within the patent office. This is in the chat. The comment was subject matter is classified by as top secret. We do have a security group that handles things related to nuclear weapons and different technologies, warfare, things like that. That does operate within the office. If things have been top secret, they do take care of it. There's a special vault. There's a whole process in place for that. That's a very tiny amount of the subject matter. And that's typically stuff that's been developed by the government, usually in conjunction with, universities and academics and whatnot. So most stuff is available. It's available publicly to everyone. I strongly urge you, like as James did, to look in the area you work in. Go to search some patents. We have it available. Find some patents and just look at them and kind of get familiar with what they look like, the language that's used, and that will really help you. When I started at the office, I'd never seen a patent, and then you get comfortable. It's like anything else once you look at it, and that will help you a lot. So. I hope I wasn't too long.
Tim, are you able to discuss improvement patents? Because you can have a patent that's still active and you're wanting to add a feature to an existing device, if you will.
Yes.
How, because the claims, if you infringe upon another patent by claiming all of the elements of an existing or previous patent, but then you're adding a new utility. So how is that navigated then?
Well,
if you-
that's actually I'm going to try to simplify that because that's actually
Okay.
pretty complex. So we would call that probably patent domination, where you have a claim which is broad enough in the first patent that it covers some other subject matter, right? Because as James said, it says comprising, it includes additional features. You've invented something that's more narrow, right? And you get a patent to that more narrow improvement, right? Is that what you're talking about has happened?
Yeah, basically I want them to understand how improvement patents work, because at the
well, I mean, when you look at it at its base, most everything we look at in the patent office is built on something else. Very
Right.
few applications are seminal inventions. Nothing is really those are rare. CRISPR in the biotech area is the thing we had recently that was a real new technology. Most everything builds on top of things that have come before it. So the way you write your application is you talk about what your improvement is, how you distinguish yourself over the previous prior art. And that's the process as you go through the examination process. You can get claims allowed sometimes, even though arguably someone else has a claim that covers them, your claims can still be patentable.
But
right?
the thing is that the whole infringement aspect is if you claim every element of another invention, then you're infringing, and you can't use it.
So I'm trying to make the distinction here, but again, between we have
Okay.
the procurement phase when we're before the office and we're considering whether or not the claims are patentable, right? And now
Okay.
now the patents have issued and we're enforcing the patents. So that's where we talk about this domination. If someone has a patent, a broad claim that covered your narrower claim, you could still have a valid claim, but you may need to get a license from that person. Right.
That's how you do that. Okay.
Right. So that goes to another thing beyond the scope of what we're talking about. But that goes to the economic value of patents, right? And even if you don't produce things, you can license them depending on the subject matter. And through that, you can derive royalties and income and things like that. So that's another value to patents. But that's how that can interplay, right? You do have to go out. Part of what you do, they're called freedom to operate searches. You go out, you search the patent literature, you find out who has broad claims that might cover what you're working in, right? And you see if those claims are enforceable. I used to do that at the law firm. That's some of the work we did. You look for clients to look for those kinds of things. So that's a whole nother area, as you're developing intellectual property that you need to consider for sure.
Now, one of the things that James mentioned is that in general, you guys don't like, patent examiners don't like applications that include both a method and a device. Or
I would not. Okay. Applicants are entitled to present claims to whatever they want in their claims. I don't know that there's examiners don't like. There's a process in the office because of that and because of burdens on the examiners. As to looking at multiple, we consider we kind of think of those as being separate inventions, right? Some people might really specialize and focus on, say, working on chemical compositions, and then other people work on methods of making chemicals, and those can be very, very different, right? The processes of all the components of a process, all the steps of a process compared to a method. So we are allowed as examiners, if you give us that, we can separate those and force you to file a separate application, right? So as that's another matter about, but if you can present more than one invention in an application, typically what happened is the examiner would ask you to pick one of those inventions, and we'll deal with that here in this application, and then you'd have an opportunity to file another application, and you could pursue the other invention in that other chain of that other.
Okay, so to help the viewers understand what we're talking about here. So if remember there was a 50.
And I'm sorry, I just want to break it. What we're going to be talking about next actually is a lot more sort of general overview of patents.
Okay.
And I think it will address a lot of these issues as well when we get into that.
Fair enough.
Someone mentioned about a Jepson claim. We really want to talk about Jepson claims. Jepson claims is a specific format of claims. Someone asked in the chat what improvement patents is. You're talking about Jepson claims. Jepson claims are a claim where you that are written of you put a bunch of stuff in the preamble and you say wherein the improvement comprises, and then you just put your improvement, what you consider to be your improvement over the prior art. Now, from a practical perspective, it's not something you would usually want to do, because what that allows the patent examiner to do is you have admitted that everything before that my improvement was known in the prior art. And we don't have to go find any of that. We normally have to go find a reference, right, that teaches all these things you're claiming. But if you give us a Jepson claim and you say a blah, 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 having an X, Y, and Z and a this and a that, wherein the improvement comprises, you know, Y, we only really have to find Y and a reason for doing that. And all the rest of that is admitted prior art. So that's the negative side to filing a Jepson claim. Some people will file them. Sometimes you'll even see them then cancel them and present it in a different format. Because it's only admission as long as the claim is pending. But anyway, that's probably a bit more technical than we needed to get into.
Okay, fair enough. Any more questions? Cyril, I'll turn it over to you.
Okay, thank you, Ms. Sherry. Sherry, thank you, Ms. Sherry. Thank you, Tim. So we're going to take a little 3 to 5 minute break right now.
Actually, I think the next one starts at 4:40. Is that what so we have some time.
That'd be about 20 minutes, I guess. 19 minutes, 20 minutes?
Yep, roughly. So let's take a short break there, and then we'll be back.
And the next session starts at 4:40.
Yep, thank you.
All righty. See you guys on the next other side.
Thank you.